to Uganda, there's unfortunately not a lot to report. The Lord's Resistance Army defendants are still at large. They're reputedly now wreaking havoc in the DRC and maybe in the Central African Republic as well. So we're hopeful that some of these new initiatives, the satellite imagery, the on-the-ground work, will eventually flush them out and get them in front of the tribunal. There is a sense that the Lord's Resistance Army is an army that, if decapitated, will simply dissipate. They will not simply replace him. He is such a messianic figure that if Joseph Kony can be captured, there is a sense that that would neutralize the Lord's Resistance Army, and so we're hopeful in that regard. One important development is that Thomas Koyelo, who was a commander of the Lord's Resistance Army, has been taken into custody. Uganda has created a special set of sort of international crimes division within its domestic system in order to enable the prosecution not only of Lord's Resistance Army individuals, but also, it is hoped, Ugandan People's Defense Forces, the Ugandan forces, who also have been accused of committing atrocities in the field. And so the hope is that there will be some equality there of prosecutions going forward. This is a new development, so it's something to keep our eyes on. The DRC has been the most active situation. We have individuals in custody. There are cases moving forward. The parties have put the Lubanga case actually to the judges. That would be the first substantive judgment that would be issued. A little interesting development is some individuals who have testified on behalf of the defendants actually applied for political asylum while they were in the Netherlands. And this has created a little bit of a political crisis that had never been done before. And so the question was, what was the obligation of the court to respect that right of individuals to apply for asylum? They had an agreement with the DRC that these individuals would not have outside contact while they were testifying, but they were able to get before the Dutch authorities and put through Dutch lawyers and put their asylum applications in. The court has said, we think it's safe to return these individuals, that they will not fear persecution if they were to return home. But, says the court, we recognize that this is ultimately a decision of the Dutch government. So those asylum proceedings are moving forward. The main charge in a lot of these cases is this idea of recruiting and using children, child soldiers, in conflict. And there's been some very interesting counter-evidence that has been churned up by the defense. Individuals saying, listen, the data that you have from this region on child soldiers comes primarily from demobilization centers, where child soldiers come forward, they turn in their weapon, they get a kit of materials, they get some rehabilitation, etc., and then they're brought back to their home communities. And a non-governmental organization working with child soldiers has conceded that basically the word got out that if you walked into one of these centers and you said you were a child soldier, you get a great little kit with a blanket and this and that, and you get some food and you get clothing. And so, there's some contestation about how many child soldiers were being used, and it will be very interesting to see what the court says in terms of what their ultimate findings are. The Central African Republic, the one individual here is Jean-Pierre Bemba, who actually is a citizen of the DRC, although he's accused of leading a militia that had been brought into the CAR to quell an insurrection there by a former president. And the situation here is really characterized by gender-based violence, which is one of the reasons why having experts on gender-based violence at the court is really important. All of the situations involved by claims and allegations of gender-based violence. A little quirky development with regard to Bemba is he's planning on running for president in the CAR. He's applied for pretrial release a number of times. He has never been granted. And he has made the argument that he can, in fact, run from his cell in The Hague. And so there's a number of sort of, that's obviously being contested. There are some lawyers in the CAR that said actually you have to be physically present in order to be able to run for president. But he's certainly squeezed out other potential candidates from his political party, and so we'll have to see whether that's going to go forward. Something to keep in mind is Côte d'Ivoire. This was mentioned. The court has two jurisdictional preconditions. It can only hear matters, if it doesn't have a Security Council referral, it can only hear matters if the territorial state is a member, or if the state of nationality of the accused is the member. So you've either got to have the territorial state or the nationality state. The Security Council can override either of those, and that's why we can have Sudan and Libya, neither of which is a party, actually before the court, because the Security Council has the power to override these two jurisdictional preconditions. But the drafters of the statute were clever in that they created a mechanism for an ad hoc acceptance where a state could say, with respect to this crime, and we don't know what that means, how broadly this crime is going to be defined, we accept the jurisdiction of the court. And Cote d'Ivoire has done one of these ad hoc declarations with respect to their post-election violence. If you remember, President Gbagbo refused to accept the outcome of the election, and it caused a number of, there were clashes all over the country between he and his political opposition. That ad hoc referral has been reaffirmed now by President Ouattara, and so the court is moving forward with investigating. The New York Times just reported that there have been 12 indictments issued. And so this has triggered this question of complementarity. Is Cote d'Ivoire doing enough that the ICC should stand down, or are those indictments not parallel to what indictments would be brought for the ICC? I've heard, although I haven't seen these indictments, that they tend to focus more on corruption crimes and not on crimes of violence. And so it may be that there's room for concurrent jurisdiction here. And so this will be another situation to watch. The only other Article 12.3 ad hoc declaration that has been made is by the Palestinian territories. And as Fatou Bensouda mentioned, that is still under consideration. There's very complex jurisdictional questions about whether the Palestinian territories constitute enough of a state in which to have the ability to refer itself to the ICC, and that's been under consideration.